Disinheritance of children and descendants provided for under Articles 915 to 919 of the New Civil Code. Article 915. A compulsory heir may, in consequence of disinheritance, be deprived of his legitim for causes expressly stated by law. All compulsory heirs, whether mentioned in the will or not, are entitled to what is called a legitim. A legitim is that part of the testator's property which cannot be given away, because the law has reserved it for the following compulsory heirs. Number 1, legitimate children and descendants, with respect to their legitimate parents and ascendants. Number 2, when there are no legitimate children and descendants, legitimate parents and ascendants. Number 3, surviving spouse. Number 4, acknowledged natural children and natural children by legal fiction. And number 5, other illegitimate children. Compulsory heirs cannot be deprived of their right to inherit, even if the testator has explicitly excluded them from his will, as they are protected under the New Civil Code, unless they have been duly disinherited by the testator. Disinheritance refers to an act by which the owner of an estate deprives a person who would otherwise be his heir from inheriting it. It can be made only through a will wherein the legal cause thereof shall be specified. It must be expressly stated in the will and not merely implied. It must be total in application, and the heir whose share is disinherited must be specifically identified. For a disinheritance to be valid, it must comply with the following requirements. Number 1, it must be made in a valid will. Number 2, the identity of the disinherited heir is clearly established. Number 3, it must be made for a legal cause. Number 4, it must be expressly made. Number 5, the cause of disinheritance must be stated in the will. Number 6, it must be absolute and unconditional. Number 7, the disinheritance must be total. And number 8, the cause must be true, and if challenged by the heir, it must be proved to be true. The proponent of the disinheritance has the burden of proof. The strictness of the requisites indicates the policy of the law. It regards disinheritance with disfavor and will grant it only with reluctance because disinheritance results in deprivation of legitim. The effect of disinheritance is not just deprivation of the legitim, but total exclusion of the disinherited heir from the inheritance. Thus, the disinherited heir forfeits number 1, his legitim, number 2, his intestate portion, if any, and number 3, any testamentary disposition made in a prior will of the disinheriting testator. Article 916. Disinheritance can be effected only through a will wherein the legal cause therefor shall be specified. The first clause of this article constitutes the first requisite of disinheritance, that is, it must be made in a will. The will must be formally valid and must be admitted to probate. The legal cause is the second requisite for a valid disinheritance. The causes allowed by law are enumerated in Articles 919 for descendants, 920 for ascendants, and 921 for the surviving spouse. Article 917. The burden of proving the truth of the cause for disinheritance shall rest upon the other heirs of the testator if the disinherited heir should deny it. Under this article, the truth of the cause for disinheritance is not presumed. It must be proved. All that the disinherited heir need to do is to deny the cause, and the burden is thrown upon those who would uphold the disinheritance. Article 918. Disinheritance without a specification of the cause, or for a cause the truth of which, if contradicted, is not proved, or which is not one of those set forth in this code, shall annul the institution of heirs in so far as it may prejudice the person disinherited. But the devices and legacies and other testamentary dispositions shall be valid to such extent as it will not impair the legitim. If the disinheritance lacks one or more of the requisites mentioned in this article, the heir in question gets his legitimate. As to whether he will also get any part of the intestate portion or not, this depends on whether the testator gave away the free portion through testamentary dispositions. If he did, these dispositions are valid and the compulsory heir improperly disinherited gets only his legitimate. If the testator did not, the compulsory heir will be entitled to his corresponding share of the free portion as well. Article 919. The following shall be sufficient causes for the disinheritance of children and descendants, legitimate as well as illegitimate. Number 1. When a child or descendant has been found guilty of an attempt against the life of the testator, his or her spouse, descendants, or ascendants. Under this article, final conviction is necessary. Attempt is a generic term which includes all kinds of commission, whether frustrated or consummated. Intent to kill must be present here. Number 2. When a child or descendant has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found groundless. There are 3 elements under this paragraph. The first one is that there must be an accusation of a crime. Accusation here is used in its generic sense, which may mean the filing of an information, or the presentation of incriminating evidence, or acting as a witness against the ascendant. The second element is that the imprisonment involved must be 6 years or more. And the third is that the accusation is groundless, meaning the ascendant is acquitted on the finding that there is no crime or that the ascendant did not commit it. Number 3. When a child or descendant has been convicted of adultery or concubinage with the spouse of the testator. Under this paragraph, there must be a conviction of the crime of adultery or concubinage. Number 4. When a child or descendant by fraud, violence, intimidation, or undue influence causes the testator to make a will or to change one already made. This goes into the very essence of will-making, the freedom deprived by the child or descendant. It does not mention prevent, because if he was prevented, how can he make a will of disinheritance? Prevention is a ground for unworthiness, which has the same effect as disinheritance. Number 5. A refusal without justifiable cause to support the parent or ascendant who disinherits such child or descendant. Refusal itself is not a ground. It must be an unjustified refusal. There must have been a need and a demand for support, and the demand must have been unjustifiably refused. Refusal may be justified if the obligor does not have enough resources for all whom he is obliged to support. Remember that the ascendants are only third in the hierarchy of preference among claimants of support under Article 200, Paragraph 3 of the Family Code. Number 6. Maltreatment of the testator by word or deed by the child or descendant. In the case of maltreatment, conviction is not required, unlike in the case of attempt on the life of the testator, his spouse, or descendant or ascendant, where conviction is required. Maltreatment may be proved by preponderance of evidence. It is possible for an act not to fall under attempt on the life but to fall under maltreatment only. For example, the son shoots his father. The father is wounded but he recovers. The father does not want a scandal, so he does not file charges against the son. So he disinherits his son not against attempt but under maltreatment. Number 7. When a child or descendant leads a dishonorable or disgraceful life. The operative word here is lead. There must be a habituality to the conduct to make it fall under this paragraph. Dishonorable and disgraceful are based on the sense of the community as perceived by the judge. It is not limited to sexual immorality. It may refer to drug addiction or alcohol addiction. A child or descendant whose livelihood is drug pushing or smuggling is living a dishonorable and disgraceful life. And number 8, which is the final ground to disinherit a child or descendant, is Conviction of a crime which carries with it the penalty of civil interdiction. Under this paragraph, conviction is required. Civil interdiction is an accessory penalty that goes with the principal penalty of reclusion temporal and upwards. So take note that conviction is required under numbers 1, 3, and 8. Number 1 is when a child or descendant has been found guilty of an attempt against the life of the testator, his or her spouse, descendants, or ascendants. Number 3, when a child or descendant has been convicted of adultery or concubinage with the spouse of the testator. And number 8, conviction of a crime which carries with it the penalty of civil interdiction. This is the end of Part 1. Part 2 will deal with the disinheritance of parents or ascendants, and Part 3 with the disinheritance of spouse.